The next issue is arbitration, mediation, and litigation. As an expert attorney in construction, infrastructures, and dispute resolution, can you explain us the differences between each one?
Yes. First, I'll tell you that in my specialty in construction, an increasing number of cases go to mediation and to arbitration, not mediation and litigation. So mediation is it's a non-binding dispute resolution procedure. And whether you agree to it in your contract or you go to court, almost all state and federal courts in the country will require you in one way or the other to go into mediation first. And in my field, in construction and infrastructure, the majority of cases settle in mediation. I don't exactly know why, but they do. And people in mediation, you hear what the other side is thinking, what their arguments are, and you present your arguments, and you get a reality check from the mediator. And one argument is, in terms of the success of mediation, is that if this particular third-party neutral or independent mediator tells you in caucus by yourself what your weak and strong points are, it's sort of pushes you into arriving at some resolution, which doesn't always happen at the table that day. And it might happen 3 or 4 months down the road, but the system works. Arbitration is a binding dispute resolution procedure, and you hire a judge, so to speak. And one of the benefits of arbitration is that you're able to engage an arbitrator or a panel of 3 arbitrators, depending on the size of the dispute, who's a specialist in your field. If you go to court, and in construction, I go to court, I don't want to have a judge, or I prefer not to have a judge, who's never done construction before. He doesn't know the terminology, he doesn't know the law, he doesn't know the details of what goes on in a construction project or an infrastructure project. But in arbitration, if it's a construction matter, the parties will decide upon an arbitrator who is preferably highly skilled, and whether it's cybersecurity or intellectual property or a variety, whatever the topic is in arbitration, you select your judge. It's a confidential process in court. Everything you file in court is public. You can come to the United States and get the pleadings of any case you want that was filed in the federal or state court system. In arbitration, it's not like that. Arbitration is generally faster. It's considered now that the international arbitration and domestic arbitration takes it's ballpark 2 years. If the deal is smaller, it could be a little less, but it's ballpark 2 years, 25 to maybe 29 months. And it's cheaper, even though you're paying for the arbitrators and you're paying for the costs of the arbitral institution. It's generally cheaper because it's shorter. My litigations that don't settle, and I have a construction litigation going to trial in April, and it's been kicking around in the court system for 10 years.
Wow.
You can have cases, litigation, where witnesses die, lawyers die. 10 years is a long time. And it's a long time to be involved in yesterday's bad deal.
In regarding to these different procedures, which practice is used more often?
Increasingly so, arbitration.
Arbitration is going.
Yes, and mediation. I can't tell you that everybody will agree to mediation, but I'd say the majority of disputes in the United States, whether it's the federal or state system, now mediate their cases first. But arbitration is more and more popular because, as I said, it's generally cheaper and it is quicker. There's things that are problematic with arbitration. I myself, on a personal level, I don't like the fact that there's no appeal. However, you can put an appellate process into your agreement, and all of arbitration has to be stipulated and agreed to in the underlying agreement. Otherwise, you will be in litigation. But arbitration is absolutely becoming the more and more favored.
Thanks for sharing with us this valuable information.